If a person is here and they're applying for the H-1, what happens to the family members? The family members will need to change if they're currently on F2 as a dependent of an F1 student. They will change their status from F2 to an H4 classification. For the H-1 petition, the petition is actually filed not by the employee or the prospective employee, but it's actually filed by the employer or the prospective employer. However, when you're talking about the family members will file their own separate application for their status. So they will file the I-539. Okay. Another point to keep in mind, a general point, is that if a person is already on an H-1B visa, he can actually be sponsored by another company. That is, once he's within the classification, he will have to have a new petition filed for each new employer that he works for. Some people will refer to this as a transfer. They will call me up and say, I want to transfer my H-1 to a new company. I don't like the word transfer because that conveys an idea that you have a status that you're giving to the new company, and that's actually not correct. When a company files a petition for an individual to sponsor him for the H-1B status, they must go through certain procedures and submit certain petitions with the Immigration Service. But once the person is on an H-1, if a different company offers him a position and agrees to file a petition for him in order for him to work for that company, there's not actually a transfer conceptually. What happens is the new company will go through the same exact procedures as the first company did, and they will file their LCA, then they will file the petition with the Immigration Service for the H-1 petition, and they will get the approval for the individual to work for that company. Now, one advantage of a person who is already on an H-1 is that as soon as the new company files the petition, he may begin working for that company once the petition is filed by the Immigration Service. Now, let me contrast that a bit. Let's say that he was going from F1 to H-1. If he's changing his status, he may not begin working for the sponsoring company until he receives approval of the H-1 petition. But if he's already on the H-1 and he's working for a company and he is in status, and that's important, he will have to show pay stubs from the present employer showing that he has continued his employment with company number one. As soon as company number two files the petition for him, he does not actually have to wait until he receives the approval, but he may begin working for the new company as soon as the petition is filed. One word of caution, probably you should wait until you receive the receipt for the filing of the petition before you start with the new company. Okay. Now, not everyone realizes that H-1s do not have to be full-time jobs. An H-1 position may qualify even if it's a part-time job. Sometimes people will come to me and they will say, well, the company is not ready to hire me on a full-time basis, but they will guarantee a certain minimum number of hours. I would recommend probably not going below 20 hours a week. But in my petitions, what I will typically say is, if there's any question about the employment, I will say that the person will be guaranteed a range of, say, 20 to 40 hours a week. So, bottom line is H-1Bs may be part-time jobs. Also, a person may work for different companies all at the same time. The only requirement is that each of those companies for which he will be working must have filed the petition, gotten their LCA, filed the H-1 petition for the individual, so that a person may work for concurrent employers. Okay. For H-1s, the general focus in the petition when we prepare the petitions is typically going to be more on the job in maybe the salary rather than the individual. So the determination of whether a person will qualify for the H-1 is going to be a quick decision. We'll look at his diploma, we'll look at his transcripts, make sure that he has the equivalent of a 4-year baccalaureate degree in the requisite major. So the real question is going to be, does the job qualify as one that requires a person to have a 4-year bachelor's degree in a specific major? So when you're considering interviewing with companies, do keep in mind what the job duties will be, what the title will be, and what the job description will be, because that will be a critical factor in the determination of whether or not an H-1 will be issued to you. For the H-4s, the family dependents, the H-4 status allows them to remain in the United States, but they may not work. H-4 does not grant work authorization. So that is something to keep in mind. You may have a spouse who is not happy sitting at home just watching TV. If the spouse qualifies for his or her own H-1, then you can file the application, or a company can file the petition on their behalf, perhaps. But the children cannot get work authorization. A spouse on H-4 may not get work authorization. Okay. Extensions. You are permitted to file the H-1 extension. The initial period, the maximum period that an H-1 can be issued is initially 3 years. Now, when that 3 years comes around, you're going to have to extend your H-1. And just like I was saying earlier, where if a company, a new company files for you and you're already on an H-1, well, if you're on an H-1 and you're filing for your extension, all you have to do is make sure that the petition is received and accepted by the Immigration Service prior to the expiration of your present status. Okay. Now, one word of caution in all of this: when you're filing for an extension or a different employer has offered you a position and said, we will file your H-1 for you, you will have to show that you are currently in status. And the way we show that these days is I will generally include 3 of the most recent pay stubs. The Immigration Service wants to make sure that you are presently in status, what they consider to be in status, so that you're still working with the old company or the present company at the time that you file for the new company. So timing is everything, especially these days, and also in the other video I had mentioned that there is a delay in getting the approval of what they call an LCA, or labor condition application. So it's no longer immediate like it used to be. So you have to allow for submitting the LCA, waiting for it to be reviewed, maybe rejected initially if it's the first time that company has filed an LCA, and then refiling before you can file the H-1 petition. So make sure that everything is done well in advance of the expiration date of your present H-1 status. If you have any other questions, do feel free to give me a call. I'm happy to talk to you and answer any other questions you might have about H-1s or any other issue that you're concerned with. Thank you very much for your time.